Hello, and welcome back to our series on US privacy laws. In this video, we'll be discussing the Montana Consumer Data Privacy Act, or MCDPA, which took effect on October 1st, 2024, following the implementation of 3 other US state privacy laws in July. The Act aligns with the standard framework followed by most US state privacy laws, detailing requirements for consumer rights, risk assessments, and privacy notices, among other aspects. First, let's look at the scope of application. The MCDPA applies to organisations that either conduct business in Montana or offer products or services to Montana residents, as long as they meet one of the following criteria. They control or process the personal data of 50,000 or more residents, or they control or process the personal data of at least 25,000 residents and make 25% of their revenue from selling data. Now let's look at the core compliance requirements that mirror those found across other US state privacy laws. Valid consent must be obtained through a clear affirmative act that's freely given, specific, informed, and unambiguous. While Montana primarily operates on an opt-out mechanism for obtaining consent, processing sensitive personal data and further processing of personal data is only lawful on a strictly opt-in basis. Speaking of sensitive data, the MCDPA defines it as information revealing racial or ethnic origin, religious beliefs, mental or physical health conditions or diagnosis, sex life or sexual orientation, citizenship or immigration status, genetic or biometric data, children's data, and precise geolocation. An organisation must conduct a risk assessment prior to processing these types of information. When it comes to general risk assessments, organisations need to perform a data protection assessment for activities presenting a heightened risk of harm to consumers. So this can include targeted advertising, the sale of personal data, and profiling. Now, transparency is crucial. Privacy notices must be reasonably accessible, clear, and meaningful, containing specific information such as categories of personal data, purposes for processing, information related to sharing with third parties, and the contact information, among other things. Consumers have a familiar set of privacy rights under the MCDPA, including the right to access, correct, delete, and port their data, as well as the right to opt out of targeted advertising, behavioural profiling, as well as the sale of personal data. Controllers must respond to these consumer requests within a 45-day time limit, but there is a possibility of a 45-day extension as well. Lastly, the MCDPA is enforced exclusively by the Attorney General, who can grant a 60-day cure period for organisations to remedy violations. Similar to most US privacy laws, there is no private right of action under the MCDPA. Thank you all for watching. We hope to see you again in the next video.